All right, good morning, everybody.
Good morning.
All right, good morning. All four of the defendants are present. Their counsel are all present. State's present.
Good morning.
Good morning. All right, let me get set up here. Okay, so some housekeeping matters first. Let's see. All right. I know that when we were here on Tuesday that Mr. Gathright had some motions that I think I ruled on, but I couldn't locate the physical copies. So I just wanted to make sure that we're all on the same page regarding the fact that all of the motions have been ruled upon, all right?
Yeah, sure. The only one, and I saw it was on the list, it was sent out last night. The only one that hasn't been is really the firearm motion.
Okay.
The state and I discussed, I think it might make the most sense to kind of proffer it and address it with the expert.
Okay. Well, I do have that one. So there were three motions that I located in my stack of pleadings, and I just wanted to make sure that I had addressed all of them really for the clerk as well as for Mr. Gathright. And I believe that they were, the first one was a motion to declare section 921.1416I unconstitutional as written and as applied. And I think that was the CCP aggravator, which I denied, so that has been denied. Do you need it?
I'll just check it, Judge, to make sure I got it.
Okay.
I think I got it.
Okay, I think you do too, but just to make sure. And then the other one, the second one was motion to declare section 921.1416B Florida statutes unconstitutional as written and as applied, and that's the prior capital or violent felony, which would be contemporaneous in this case. And I believe I ruled that it was denied. Just want to make sure. And then finally was a motion in limine as regards to general procedures, and there were paragraphs. I think A was granted, B was granted, and C was granted as to the names but denied as to questionnaires. So granted in part, denied in part. Individualized and sequestered voir dire was denied, and contemporaneous objections, paragraph E, was granted. All right. So, Madam Clerk, that was granted in part and denied in part as articulated. And, okay, so I think those are the three motions that I located my copies of. Also, I had taken under advisement Rashad Murphy's motion to allow testimony of the impact of defendant's execution on family members, and specifically, Mr. Rashad Murphy had cited to Lugo versus State at 845 Southern 2nd 74. I did take a look at that opinion, and in that case, the defendant had one of his proffered mitigating circumstances was that his execution will have a tremendous negative impact upon the lives of his elderly mother, siblings, and 6 children. In this case, Mr. Lugo contended that his sister passed away, he adopted her 4 children, and assisted in raising them. So in that case, what the real issue was what the issue on appeal was, Mr. Lugo he argued that that mitigating circumstance outweighed the aggravating circumstances, and the court said no, and that was affirmed. But it does appear that this mitigating circumstance was offered, which was his execution will have a tremendous negative impact upon the lives of his elderly mother and siblings. So for that reason, as the motion is drafted, I'll grant the motion. All right?
I will
So,
pass that on to Mr. Hernandez, Judge.
yeah, just let him know. And really, and this applies to Mr. Rashad Murphy and all of the defendants in this case, obviously, if we get to a penalty phase, you and your counsel can and should tell the jury every great thing about you, every redeeming characteristic about the totality of your life, okay? So, all right, very good. All right, so let's move on to which would be Mr. Gathrights, defendant's motion in limine to preclude the state from presenting firearms identification evidence, and then the state filed a motion to strike Daubert hearing request in defendant's motion. So how are you all suggesting that we handle this?
Your Honor, my position in the motion, and I know the state certainly disputes this, is that this firearms identification evidence is not product of reliable principles and methods and should not be.
I'm sorry,
submitted.
excuse me.
Should I?
Yes.
I can't hear either.
No.
This is better than courtroom one, but it's not, it's still a big courtroom.
Understood. So, Your Honor, my position is that this body of alleged science, the firearms identification, is not reliable. It's not the product of reliable principles and methods. It should not be admitted at all. I recognize that has been addressed by many courts across the country, and the courts in Florida have not been particularly receptive to the argument. So, unless Your Honor is inclined to agree with me, I think what Ms. Norton and I talked about is that the best way to address this might be to proffer the expert's testimony when that time comes and rule on it at that point. So.
Okay. All right, very good. So in light of that, I'm going to grant the state's motion to strike the Daubert hearing request, but I will allow defense to proffer before the witness testifies just for appellate purposes.
Thank you.
Okay, so just remind me that we need to do that before the firearms expert testifies. All right? So I'm going to grant the motion to strike. All right.
Judge, one more housekeeping matter. if I
Sure.
could. Judge, I hope the court has now seen that I erred yesterday when I filed my supplemental memo on severance, one addressing the court's question to me last week. When I filed a draft instead of the final memorandum, I realized that very early this morning, immediately contact Ms. Ismer, and this morning at about 8:30 or maybe before, I filed an amended. Now, I will
Okay.
tell the court that the amended is in fact very similar to the supplemental.
Okay.
There's not anything of grave change to it, but I wanted the court to be aware that that was my mistake, and I apologize to the state for not catching it this morning. We filed a draft instead of the final of what we wanted to file.
Okay, very good.
Okay, and then the other thing, judges, I know I asked the court about this earlier in the week, believing that this would conclude any motions. I did have, and I will reiterate again, a motion in limine as it relates to the state's witness, Robert Howard.
Okay.
It is not yet complete, but it will not
Sure.
require testimony and probably very brief argument.
Okay, that's fine. We're going to pick another date in the future to hopefully resolve any outstanding evidentiary disputes. And I know you all still need to get together to do your evidence view, correct? Has that
Yes,
been
sir.
scheduled yet?
I was gonna talk about that today. I know
Okay.
because of the voluminous nature of it, I wasn't even sure the state was ready to do
Judge,
that.
we do have to, we've gotten some items out of evidence, but I think there are some additional physical items that we need to get out of evidence that were put in trial. And
Right.
So we will get that done. I think the photos, for the most part, we're just gonna reprint, but they are a lot of photos, so I do need some time, but we will schedule that.
Okay, so on the lunch break today, I need you guys to figure out a prospective date for that, and then I will set a motion hearing date after that, but we need to have at least an idea of when that's gonna be, because I know your calendars are busy, and I don't want you all to get jammed up, and then we can't get together at least one last time to go over any and all outstanding motions or issues,
Yes.
okay? All right, and I know we discussed this on the state's motion in limine regarding victims' gang activity and drill rap videos not disclosed in reciprocal discovery. Did I give you all an absolute deadline? Did I pick a date?
Judge, I think they were supposed to provide it to us today, by today.
Okay,
And Judge, that would be any videos that we intended to enter.
Correct.
Any of us.
Yes.
And yes, Judge, you did give us until today to do so. On behalf of Mr. Murphy, I will not be providing the state with any additional videos.
okay. All right, and so state, you're gonna take a look at those and then let me know if you have an objection.
Yes, Judge, I believe, the attorney for, Mr. Chance provided us with a list of videos.
I
So we
did
will
see,
let-
yeah, I did see that. Okay, so I'm gonna actually reserve ruling on that motion pending the state taking a look at what's been proffered. And if I need to resolve a dispute, then I will do so, whatever our next hearing date will be. Okay? So that one I will reserve ruling on. Yes, Mr. Wise?
Your Honor, while we're talking housekeeping matters, I hope not interrupting, there is, at some point today, I'd like to briefly readdress a question Your Honor asked during my traffic stop motion after having done a little bit of research on it.
Sure,
I can do that now.
sure.
Okay. So,
When we were having argument on that motion at the last hearing date, Your Honor had asked if I would agree that finding the firearm in the car that Mr. Guthrie was in would give a basis for, I guess, arrest. I don't recall if it was an arrest or a search of the car because he's under 21. And I didn't agree with that for a lot of reasons, but having done a little more research, I don't see a basis, I don't see a reason why his possession of a firearm being under 21 and over 18 was unlawful. I know that's what the officers apparently believed, but I don't see a reason why that was unlawful. And if the state, has a reason that I'm missing, I'm sure they would bring it up. But to go back and readdress that question after having done some other research, it would, if he was under 18, it would have been unlawful, but I don't believe possessing a handgun
Under
between 18
21.
and 21 is unlawful.
Okay, state what's your argument.
Judge, even, Judge, it is securely encased, I think that he is correct, but there is a law for that, but what he was arrested for was the possession of drugs and drug paraphernalia.
No, I understand, but I think the argument was made, I think law enforcement took the position that was also,
They did, Judge, they believed that, and correctly so, that there is a law that if you are under the age of 21, you're not allowed to possess a handgun. But there is also additional part of that statute that says as long as it is securely encased, and it's our understanding that that was in the console of the car.
so do you agree that that would have been securely encased in the console of the car within the meaning of that statute?
Yes, Your Honor.
Okay, all right, thank you. Okay, all right. So, next, we will move on to argument regarding the various motions as it relates to the gang evidence and whether or not it's gonna come in. So the state has filed a motion for pretrial ruling regarding admissibility of evidence. And who's gonna argue that motion for the state?
May I be heard, Judge?
Yeah?
Maybe, Your Honor, and again, strictly up to the court, having the defense argue their motions as it relates to liminy of all of those things might subsume the state's actual motion when they argue against the same.
Well, no, and I agree. Really, the point of hearing the state first is for the state to articulate exactly what it is that they're intending to admit. So
Thank you,
that's my motivation in asking the state at this point to proceed, is for them to identify on the record exactly which incidents they are intending to introduce, and then I will have the defendants argue their various motions.
Thank you, Your Honor.
Okay?
Judge Kaplan, 1 minute.
Sure. So if I'm looking at the state's motion, it looks like you're going back as far as 2018.
Yes, Judge, I was just looking, I have so many documents, just trying to find that one.
Yes, I understand. So it looks like pursuant to the motion itself, August 18th of 2018, Joe Rod Adams, also known as Spaz, was murdered at a Rains High School football game. Adams, it's alleged, was a 1200 associate. Robert Howard and Adrian Bibby Gaynor were suspects in the homicide of Adams. Howard and Gaynor are six block members, and Robert Howard was convicted and served a 5-year prison sentence for manslaughter and aggravated battery on that case. I believe Robert Howard was also a victim in this case, and he did testify in the Andrews case. The state also alleges or discussed in February of 2019, Adrian Bibby Gaynor was shot and killed in Jacksonville, Florida. Adrian Bibby Gaynor is known to be close with the victim, Charles Jones, and is associated with 6 Block. Hakeem Cusso Robinson and Leroy Scotty Whitaker, gang members of ATK, are currently charged with murder for the death of Gaynor. Then the state identifies August 16th, 2023. Jaquan Pickens, bully gang member, was shot multiple times and killed. Bully gang is associated with and allied with 6 Block. And then August 17th of 2023, there's an attempted murder of Jacoby Beals, a 1200 gang member. This shooting was believed to have been committed in retaliation for the murder of Jake Pickens that occurred the day before on August 18th. On October 7th, 2023, Antonio Tilley, ATK gang member, was murdered. Members from 6 Block claimed credit for the murder on social media. On the same day that Tilley was murdered, immediately after, there was an attempted murder committed against the victim, in our case, Charles Jones. So I'm assuming, are those all of the prior incidents of gang violence that you are seeking to introduce?
Yes, Your Honor, that's what was outlined in my motion that we responded to, the motion for severance for Rashad Murphy. It's also what we have listed previously in all the defendants' case as under notice of inextricably intertwined evidence, Judge. Along with, there are some drill rap videos that also mention some additional gang members that we also intend to introduce. And Judge, it is the state's position that those 6 incidents, as well as the drill rap videos that we have listed in discovery as inextricably intertwined and evidence of motive, is relevant to this case against all of the defendants. First of all, the 3 defendants, Isaiah Chance, Rashad Murphy, and Davian Murphy, are gang members, and as part of our requirement for proof for that particular gang enhancement, we have to prove that they were gang members and that this crime was committed for the purpose of enhancing or benefiting the gang in some way. And Judge, we are prepared to do that. As far as Sean Gathright, we believe that it is also admissible in his case. He is closely tied to Isaiah Chance, who is a known gang member. There is evidence that he is the supplier of the gun, as well as there is evidence that directly links him to the attempted murder of Charles Jones that occurred in October of 2023. We have listed the case law for this argument for inextricably intertwined that is directly relevant to gangs. In particular, I will again cite to that Richardson case what was very clear, that there were 6 prior shootings that was introduced in that trial. That was a gang case that occurred, again, up in Jacksonville, where a child was shot and killed, and his grandmother and another woman in the car along with him were shot at but unharmed. And what the court went through is this whole argument about inextricably intertwined, and the state in that case was able to show to the jury through the documentation by the gang itself, that's how it qualified these drill rap videos, was the fact that this gang war was documented by the gang members themselves on social media, by not only drill rap videos, by social media postings. All of that was evidence of motive, and the court acknowledged that that was highly prejudicial, especially the prior shootings, but it was not substantially outweighed by the probative value of motive. And that is what this is in this particular case. It is motive. It tells why in Richardson, why that baby was shot, because there were gang members that were standing on the street where that baby and his family were. And it provided the explanation why that shooting happened, the motive. And it is the motive in this case, that historical gang war actually will show the jury all of the reasons and give context to why this shooting happened. And so it is highly probative. Motive evidence in any case has a very significant probative value. And the court went through that analysis and said that that background, even the collateral crime evidence of the prior shootings, was not outweighed, that prejudicial effect was not outweighed by the probative value. And it is necessary for us to be able to actually explain to the jury what led up to this shooting, what was the motive, why they all came down to Tampa in one day for the specific purpose of shooting Charles Jones. And it all has to do with this back and forth gang war that is going on. 3 of the people of the 4 that are left are part of the gang that are allied together that dislike Charles Jones. Those drill rap videos, the evidence on social media that shows the back and forth, all of those are connected to these 6 incidences that we have alleged. In particular, Adrian Bibby Gaynor has a relationship the first one is the Rains High School where we start. Joe Rod Adams, I apologize, starting with that one, in 2018, he had the nickname Spaz, was a Gang 1200 associate, and is related to the Murphys. So obviously, going back to that specific case, especially since Robert Howard, who is also a person that was with the victim when he shot and is a witness in this case, is relevant and gives history to the significance of the motive in this particular case.
Okay, and I'm not meaning to cut you off, and just so everyone knows, the first thing I really want to discuss and what I'm gonna rule on today initially is regarding the introduction of the evidence related to the 6 specified incidents in the state's motion, all right? Because then, once I rule on that, then we can have a discussion regarding what drill rap videos and what other evidence is gonna come in once I've ruled on the admissibility of the 6 previous incidents.
And Judge,
Okay?
I may ask for the assistance of Ms. Ismer. She has kind of taken over this area for us and covering with the state, and to some particulars, I may require her assistance in responding to the particular specific reasons why they're relevant to the case.
Okay, and that's, you mean as far as the drill rap videos or the actual previous incidents?
Both, Judge.
Okay, so, yeah, so what I'm trying to say is that any objections to any specific videos, I will address that after I've ruled on just the general nature of the gang evidence coming in. Once you all know the parameters of what's gonna be admissible, then we can visit if there's objections to certain drill rap videos, whether or not they come in, okay?
Okay.
Okay, very good. All right, anything further before I turn it over to the defense, just with regards to the 6 previous incidents?
And Judge, I know that we probably will go through one by one, but some of the defense motion and limines that have to do with gang, there's several paragraphs that lists different items. And so at some point, when we go through those items, I would like the opportunity to address those items.
Sure.
Okay, thank you.
Absolutely. And, one question, there was testimony that Joe Rod Adams is actually the brother of Davion Murphy. Is that correct?
Judge, there was testimony, I believe, by one of the detectives. They knew that there was a relationship. They had him referred to as a brother, but they were not absolutely certain as to whether it was a brother or a cousin. But they are sure that there is a relationship between both of the Murphys and Joe Rod Adams.
Okay.
But
And-
he did at one point believe that he was a brother to, I want to make sure, Rashad Murphy and cousin to Davion. I now believe that that is the reverse. Is that correct, Ms. Ismar?
The only evidence that we have to support the relationship is that there's a familial relationship, that they are cousins. There was some discussion, but proof as far as setting that forward at trial of a brother relationship, other than referring to them as their brother, is.
So I was gonna ask you, what is the state's proof? Unless the defense is conceding that they're related. Mr. Gonzalez? Excuse me, well, it'd be Mr. Gonzalez and then also, Mr. Sonardi.
Sonardi.
I'm sorry.
Well, Judge, I think it's the state's burden
I agree.
to provide testimony and evidence that they are in fact related in some way, shape, or form. So I would ask the court to defer to their proof in answering that question.
Okay, same, Mr. Sonardi?
Same for
Okay.
Davion Murphy.
I'm just asking the question. Okay, so what's your
Defendant's
proof?
Statements are calling Mr. Joe Rod Adams their
Whose
brother.
statements?
Mr. Murphy and, Mr. Davion Murphy and Mr. Rashad Murphy refer to Joe Rod Adams as their brother.
And was that in text messages or how-
In their interviews.
in their interviews?
Correct. More recently, there are phone calls which Davion Murphy has made with his mother, which indicate that the relationship is cousins. The detective's evidence as far as following the gangs, that they provided to us in preparing for the case were that the relationship established that they believed it to be was a cousin relationship. But the reference that we have is that they are brothers. I cannot tell the court whether that means that they are blood related or they just refer to each other as a brother.
Okay. Okay, very good. Okay, so who wants to go first?
I'll go, Your Honor.
All right,
Brian Gonzalez on behalf of Rashad Murphy. Judge, how the state of Florida gets to the point where they can elicit this type of evidence is the issue here. The second motion in limine, in addition to the Dahlberg challenge, requests that the court prohibit the admission of law enforcement opinion testimony and related evidence concerning A, alleged prior gang war history, hearsay-based gang intelligence, and purported uncharged gang-related incidents. It's our belief that the state is going to attempt to present to the jury a large and sweeping narrative that goes back 6 years, at least as referenced in the state's motion for pretrial ruling on admissibility, of a gang war in Jacksonville that includes multiple groups, dozens, if not more, of individuals, a series of shootings and homicides going back to, based on their motion, 2018. This murder being in June of 2024. The state argues that this evidence is inextricably intertwined and that it establishes an underlying motive for this particular offense, the murder of Charles Jones. And it's our belief that that is not supported by admissible evidence. Through what now appears to be 3 detectives, Detectives Nieder, Griffith, and McCullough, the state's going to attempt to introduce opinion testimony, which I submit to the court lacks, or labeling historical violence as retaliatory conduct, and also utilizing a plethora and what is the primary basis of their testimony being hearsay-based intelligence derived from reports from other officers, confidential informants that are undocumented, lyrical interpretation of, by opinion testimony of rap videos, evidence of uncharged and unsolved shootings, wholly, by the way, unconnected with Mr. Murphy. And collectively, I believe it invites the jury to decide somebody's guilt, in this case, Mr. Murphy's guilt, based on association and propensity rather than admissible evidence. The relief I'm requesting in detail is on page 2 of my motion, and the court will read that in her ruling.
And I'm sorry, we on your second motion in limine or third?
It's number 2, Judge.
Okay.
To that extent, the state is going to have detectives outline a history of this conflict going back to 2018, most of which are unsolved, and none of which are alleged to have been committed by Mr. Murphy. There will be testimony from detectives about gang affiliation as it relates to Mr. Murphy, as it relates to Rashad Murphy, as it relates to Mr. Chance, and there won't be any, I believe, as it relates to Mr. Gathright. The testimony is also going to outline the gangs themselves, the nature of the gangs, inclusive of their background and their history, sometimes going back to their inception, long before any of these detectives were involved in their particular investigation of those individual gangs, collectively or individually, and also how these gangs are not traditional gangs, they're hybrid gangs. They have no hierarchy, they have no rules, they have no consequences, they have no punishments, and that is an important aspect when we talk about how they differ from a traditional gang where one member does things only at the behest of other gang members or at the behest of the gang as a whole. There are individual motivations in these hybrid gangs that may not have any involvement, any other than an individual grudge or a particular issue between one person and another, that doesn't trickle down to any type of group gang type decision or plan, and that is the nature of it being a hybrid gang that mostly is derived historically based on neighborhoods or where you grew up. As it relates to testimony last week, Judge, and I'm going to run through this very quickly, Detective Nieder has 7 years on the job at the Sheriff's Department. He was assigned as late as 2022 to the gang unit, and at that particular time, he started working exclusively with ATK. He has taken 3 yearly courses at the beginner and intermediate level through HIDA, H-I-D-T-A, and these are 3-day organizational crime conferences where general gang intelligence is discussed, and they also do not provide any comprehensive instruction. And this is based on testimony from Detective Nieder, whether it be at the hearing or sworn testimony from his deposition, and that's set forth in the motion with particularity as to where the court can find that. He essentially admits during his deposition that the majority of his training and experience comes from on-the-job training and based on what other detectives had told him prior to him coming on board. Although he alleges that he speaks with a number in a group and on a regular basis, community members, they don't openly discuss gang details to where they are documented, to where there are reports, to where there can be testimony as to who they are, and certainly those witnesses will not be testifying in court. As it relates to Detective Drabeck, I'm going to pass him, as I understand by the court's ruling, that he's going to be testifying to this particular investigation in and of itself and will not be testifying to any historical information. As it relates to Detective...
Correct, not as a gang expert.
Correct.
He's a fact witness.
Yes, Judge. As it relates to Detective Griffin, he has been with the department for 16 years, but he didn't join the gang squad until 2021. And for him, he's been through that same HIDA training for 21 through 24, 4 weeks total. And he has never been qualified as an expert or given testimony as an expert. And essentially, he pretty much says the same thing as Detective Nieder says, acknowledging that his knowledge of 1200's activities prior to 2023 is very limited, and he does not have any witness with firsthand knowledge of any group dynamics. All of his testimony, again, is contextual inferences by unknown individuals that he cannot document, he can't tell us when, he can't tell us who, and he can't tell us with particularity what they say. As it relates to Detective McCullough, he began in 2022, and essentially he is in charge, and that's after a long standing history with the department itself, but again, in 2022, January, and he became assigned to 6 Block. He also went through the HIDA training. He also went through and did a couple of other trainings of general types, and talks about how social media downloads, rap videos, interaction, again, with community members would be his source of information, again, with no particularized documentation of any kind in any way, and would not be able to testify to that if given an opportunity to testify to these historical issues. He also had some, he was unsure exactly if he'd ever testified before as an expert. He does recall testifying a couple of times. He thinks just in front of a judge and the state attorney, which might lead me to believe it was either a motion or a sentencing. It doesn't appear that he's testified as an expert as it relates to any type of trial testimony.
Well, let me just ask the state something. Who are you intending to call as your gang expert?
Judge, 3 witnesses, Detective Nieder, Griffin, and McCullough. They each are specialized in a particular gang that is involved in this case, and all of them have years of experience in that gang unit monitoring these gangs.
So, but we can't have cumulative testimony.
Correct, Judge, and we will not, it will not be cumulative. There may be 1 or 2 that we cover it all with 1 or 2 and not call the 3rd, but we have just listed them under the abundance of caution if there's something that one of them cannot speak to.
Okay. Okay. Okay, we'll cross that bridge when we get there, so.
And Judge, it's my expectation that we will rely on one of them mostly for the expert testimony, but as far as the documentation, there is documentation. Each one of those gang members have been documented with field incident reports that are maintained by the specific person assigned to that gang, so there is fact-related evidence as well. So we are not intending on offering cumulative evidence.
Okay.
And Judge, what I anticipate Ms. Doherty is talking about is a particular report where a person is documented as a gang member pursuant to statutory criteria. That we're not talking about testimony from people as to their gang history and what they do and what they did and what they might be accused of doing and how they relate potentially to a particular murder or a particular shooting. None of that. What Ms. Doherty, I believe, is talking about is the singular report where a particular person is documented as a gang member and under these criteria. And certainly you look at those criteria, and in and of that criteria are unknown interviews with unknown people.
Sure, so, but there's 2 separate issues here, right? Okay, so what we're discussing right now is the historical
Agreed.
evidence. That's
Agreed.
all we're
I
discussing.
just wanted to respond to.
Yeah, no, that's fine, because and that's what I'm focused on right now.
Understood.
What's the parameters of the historical evidence that's gonna be permitted to come in? And 3 of the defendants, the state has identified for aggravators as being gang members or associates.
Correct.
And so that's a separate issue as far as the state's proof and who they're gonna call to establish that, okay? So I just wanna make sure that we're clear what I'm focused in on at this particular moment is the history and how much of that's gonna come in.
So I'm mistaken, because I thought Mr. Gonzalez said he was on to his second motion in limine, which he's challenging the expertise.
We are.
We are, and we'll get there,
Okay.
we'll
All
get
right.
there,
I
but
apologize, Judge.
I'm gonna first deal with the issue of the admissibility of the history of the gangs in Jacksonville.
Yes,
okay?
Judge. So in my motion, and I'm not going to go into it because I want to get to other things, I give the court what I believe, based on testimony of detectives at deposition, the backgrounds as to each one of the gangs themselves, 1200, ATK, 6 Block.
Because there are a lot of incidents, it looks like in your motion, Mr. Gonzalez, that the state's not seeking to introduce evidence.
They are, Judge, but they were testified to at deposition, and we did not know until we got this
Yes.
motion
Okay,
for
that's fine.
admissibility.
So, because at this point, the state has identified 6 instances, 6 historical events, and that's the universe at this point of what the state is seeking to introduce.
And
So-
I'm going to just touch on each one of those.
Okay.
Only those 6, not all the ones that are in the motion, because when the time I wrote the motion,
Right.
we weren't there. So
Okay,
I
very
will
good.
touch on those very briefly, because they are in much more specificity and particularity in the motion, but I'm not gonna just track the motion, I'm just gonna try to give
Sure.
some bullet points on each one of those circumstances.
Okay, thank you.
The gang war narrative, Judge, they are all listed, inclusive of the 6, in the table that I have in the motion. And I just would ask the court to look at that table. Now, you can cut it down to those 6. Just gives an overview of each one of those circumstances. As it's reflected in each one of these detectives' testimony, many of those incidents remain unsolved. Certainly, in trying to determine who might be associated with what, there's not enough evidence to charge anybody with anything. None of these defendants, no one else that might be associated with any kind of gang, and therein lies, even at its root, a problem with what they would like to testify to, as it relates to opinion that can't be buttressed by what I believe is admissible evidence, especially as it relates to Mr. Murphy. The state's going to introduce law enforcement testimony that establishes a victim, that talks about a perpetrator's gang affiliation, but no testimony about any one of these individuals specifically involved in any one of those circumstances, except for maybe some testimony as it relates to Mr. Jones's attempted murder on October 7th, because they're going to take a leap and they're going to talk about Mr. Chance and potentially Mr. Gathright, but mostly Mr. Chance. Without establishing this gang association, and I don't mean criteria under 874, I'm talking about evidence from witnesses. I think the state's intent here is to try to fill this evidentiary gap with testimony from one or more of those detectives, and they're going to cloak it as expert testimony or opinion, but regardless of whether it is, it's based on hearsay, it's based on speculation, it's based on contextualized inference, none of which is admissible under 702. So I asked the court to make that correlation as you determine these issues. Of the 6 incidents that we're talking about, take a quick glance.
Sure. So just, again, to recap, August of 2018, the murder of Joe Rod Adams.
Mr. Howard was convicted of manslaughter in that case.
Yes, he was, and will be a witness in this case, correct?
Oh, he will be a witness, and certainly we'll have an emotion limine on that, and I would, based on his deposition and based on his proffer, waiting to hear what he might say on the stand under oath about gangs.
Okay, well, and
about
again-
gang association.
And again, the only reason I raise that is because that's actually someone who will be testifying with direct knowledge of these incidents, right?
Direct knowledge of what, Judge?
Of he was convicted and served a 5-year prison sentence for the manslaughter and aggravated battery.
Yes, I
regarding
believe he will
the-
testify under oath that,
Right.
in fact, that's the case.
Which means he can be cross-examined.
Correct.
Which is my point.
Yes, Judge. And now what other contextual knowledge he may have about anybody here or gangs in general,
No, I
that's
know,
another
I
story.
know, I'm just trying to draw the distinction between at least that incident. The state will have, some direct evidence with a witness who then can be cross-examined, right?
Yes, Judge.
Okay, all right.
Now, I don't believe it will be as it relates to evidence that I'm suggesting in this motion, is inadmissible or not inextricably intertwined. But nonetheless, we get there when we get there.
Right.
Judge Adrian Bibby Gaynor, Hakeem Kesu Robinson was charged in that case.
Right, and that was from February of 2019.
Yes, Judge.
Okay, and then we move on to August 16th of 2023.
Yes, that's Jake Jit Pickens. That case is unsolved. Jacoby Beals is unsolved.
And that's from August 17th of 2023, correct?
That's correct, Judge.
Okay.
Then October 7th, Antonio Tilley, Jawan Mills was convicted on that case, but I don't believe there's any gang association based on testimony from detectives, and I'll get to that when I get to that individual case. And then we have October 7th, which is Charles Jones' attempted murder. That is unsolved as well.
Okay.
So, Judge, while it might be reasonable to attribute some level of reliability to law enforcement intelligence that's derived from social media, in this instance, the basis for opining that groups, either in rap videos or in social media that no one's gonna be able to testify to, right, other than there was some. When, who was on it, what date, who said what, none of that the detectives are capable of testifying to. They can't testify to a rap video and their own speculation and their own opinion as to what that rap video might say, but when we talk about taking credit for something, because that appears to be a big issue, taking credit. The court might remember that Detective Nieder testified that taking credit is actually trolling. You're trolling the other side. You're disrespecting the fact that that murder occurred. You might even be lauding that that murder occurred or that shooting occurred. And certainly, the state would like you to take the leap or allow a jury to hear or allow somebody to testify to, that's an admission of committing a crime. And I would ask the court to look very closely as to whether or not that inference is admissible. Essentially, just briefly, Detective McCullough, when asked, are you saying they're claiming credit for some of these shootings? What do you mean by that? Well, they'll get on social media, Instagram or Spaces or Clubhouse, which is like a social media platform, and they'll just start talking about it. He got what he deserved, stuff like that, just claiming, basically taking responsibility for it. None of that insinuates anyone is taking responsibility for anything. They are rapping about it. And he says that in one part of his response, but then would like to suggest that basically they're taking responsibility, which again is an inadmissible opinion on his part that's not buttressed by any evidence. No one is specifically saying I did this. Well, of course, as we talked about, nobody gets on a video and says, I killed this guy. And I guess that's not what I was asking, but his answer is correct. People are not saying they're just taking credit for it. So, what's happening in these social media posts and sometimes in these rap videos are the same thing that's happening at the same time out in the community. Somebody gets killed, there are thousands of people talking about it. People hate it, people like it, people laud it, people think it was deserved, people know what happened, so-and-so got shot, so-and-so was walking down the street. This is a community whereby social media, the ability to have knowledge and information is quick. And detectives testified to that. This is not relegated to one single group or one single person that knows about what happened to somebody. It's what they say about it. And therefore, we have to be careful, I believe the court has to be careful, not to suggest to the jury and not to allow evidence that would lead a jury to believe that somebody had something to do with something when that's not what they're saying.
Right, I agree.
Judge, talking specifically about the 6 instances, I'm trying to talk as fast as I can. Joe Wright Adams.
Right.
The state is going to suggest that there's evidence to believe that Joe Wright Adams is a cousin of Rashad Murphy and Davion Murphy. This occurred in August of 2018, 6 years prior to this particular case. Detective Dishman was the lead detective in that case. In her deposition, she actually said that in investigating this case, that the argument developed over a girl. And it escalated, and at one point in time, Mr. Howard, a state witness, told a person, somebody's gonna die on my 8. And then Dishman testified that she believed that Howard was talking about his friend, Lawrence Davis, who's called 8. That's the evidence of this gang affiliation in my mind. What ends up happening subsequently is that Bibby Gaynor is alleged to be a second shooter. He's not charged. Mr. Howard ends up either taking the rap or pleading guilty to a manslaughter on what was an alleged first-degree murder. And essentially along the way, the whole case falls apart because people recant what they were saying. They say they weren't telling the truth.
Right.
And they say they got threats. None, law enforcement can't corroborate any of these claims.
Well, let me see this, Mr. Gonzalez. Let's just assume the state has evidence, enough evidence to go before a jury to make the argument that Joe Rod Adams was in fact had some close relationship. They even, whether or not they were actual family members, maybe referred to themselves as family members, whatever that may be. Wouldn't that be direct evidence potentially of a motive involving Davion and Rashad Murphy?
No, Judge, I think we have a significant remoteness involved. I don't believe that the jury should be led down a path that simply because one person was related to another,
Right.
that would provide the modus
Well, let me ask
to
you
kill
this,
somebody 6 years later.
and remind me, and I may be getting, because I may be misremembering, but was there not a video that Mr. Jones is performing in, or someone affiliated with Mr. Jones, where the grave site of someone's being desecrated? Am I remembering that correctly?
You are, Judge, it's another incident though, that's the town center shooting, but
Okay.
there are references, I'll let Ms.
Yes, Your Honor, that is correct, and it is of Mr. Joe Rod Adams. It is
Right.
gravesite.
Right, so
That is
Joe
the
Rod,
part.
right, Joe Rod Adams, and again, I'm just assuming for the sake of argument that there is evidence that there is some close relationship between the Murphys and Joe Rod Adams. He's murdered, and then Charles Jones actually makes a video where I think that they're pouring alcohol or something on the gravesite.
That's correct, Your Honor. So there was an initial video where it's believed that someone was urinating on the gravesite.
Right.
And Mr. Jones is alleged to have taken that a bit further and made an actual video with beverages or something and
Yeah.
poured on the same.
Yeah, I mean, okay. I just want to make sure I'm getting my facts correct.
And Judge, that's addressed in the motion when you get to it. As it relates to Bibby Gaynor, February 15, 2019, 5.5 years prior to this murder, essentially, Mr. Gaynor is allegedly, well, not allegedly, he's killed by Hakeem Robinson, and essentially Detective Oliver was the lead detective in that case. He was deposed. That was unsolved for about 18 months. Only at such time as a jailhouse snitch came forward and gave information that connected that murder to some type of retaliation, that law enforcement was able to make that connection and attempt to run with that particular theory of prosecution or theory of the murder. At this particular time, I don't believe that person is going to be testifying. It's hearsay. I don't believe that anybody is going to hear from a person who had direct knowledge of what happened, or why it happened, or under what circumstances it happened. I think that Detective Drabeck, in his deposition, stated that as it relates to Gaynor's murder, that although he was a suspect in Adams' murder, that he wasn't charged with because everybody recanted, that he opined that Adams' murder was not the nexus for Bibby Gaynor's murder. That's what he says on page 29 and 30. Instead, he believes that the murder happened out of pure opportunity, not revenge, not retribution. And that's his sworn testimony.
State, just real quick, what's your response to that in regards to?
Your Honor, since the depositions have been taken of those detectives, Queso or Hakeem Robinson, very prominent ATK member, has since been convicted of that crime. And so, understanding the defense's argument that the weight of that evidence could be that there's some other reason why that killing occurred, it is yet another act of violence which occurs months after Mr. Howard is arrested for the murder of Joe Rod Adams in killing the other person suspected to have been involved. So the 2 6-block members that are allegedly involved in the homicide of Joe Rod Adams in 2018, one of whom is arrested for that murder, the other of whom is killed in February of 2019, and then obviously now subsequently convicted of that murder.
Okay, thank you.
Judge, next, briefly, is Antonio Tilley, October 7th of 2023. Tilley, there'll be testimony from detectives. Again, and I'm not going to go over each time when I talk about testimony from detectives. The court already knows my feeling on how this testimony is going to be elicited from detectives and where they get the information. And I think at the root of the problem, it all is the same. So I'm not going to say that every single time, but every time I mention a detective and every time I mention what that detective is going to testify to, it's really under the same circumstances and same ability that he's going to be testifying to. Somebody else told him that we don't know who it is. Some social media post said it. Some Instagram Live said it. It's not documented. There's no report. There's no witness that's going to testify to
But
it.
can't gang experts testify to that?
No, Judge, I don't believe they can.
Okay.
Tilley was supposed to be an ATK member. Detective Anderson was the lead detective. Essentially, this was a contract killing. That's what the detective said who investigated the murder. And essentially, it was done by Jaquan Mills. Jaquan Mills is not a gang member. To my knowledge, and based on testimony from detectives, Jaquan Mills is not affiliated with any gang. Essentially, as I understand it, Detective Anderson testified that the suspected contractor is a guy named Paul Anderson, who is now doing a 25-year sentence for drug-related activity. I don't believe there's any indication that Copeland or Anderson are related to 1200 or 6 Block, at least on any basis I know, unless somebody's going to testify to it now, and probably under the same premises that they're going to testify to everything else that they testify to. Anderson then did defer to Detective Nieder in his deposition, and essentially he said, my understanding is that Detective Nieder suggests that Tilley had something to do with Cedarian Copeland's son being shot. So that's potentially the reason all this occurred. We now get to October 7th, 2023, which is Charles Julio Jones. Obviously, that case is unsolved as well. Now we start dovetailing into evidence I believe is in fact potentially admissible against one defendant and shouldn't be admissible against others.
Which is what?
Which is NIBIN matches between the shell casings recovered on October 7th at the scene and casings found in Sean Gathwright's vehicle. And essentially, Detective Nieder, based on the same analysis, is going to say that Jones was shot in retaliation for Tilley. And he believes that Isaiah Chance was involved, and his opinion is that Chance and Gathwright were close friends, spent a lot of time together.
Well,
and
the state's not going to be able to get into that.
Well,
It's
that,
unsolved, and Detective Nieder is not gonna be able to opine that he thinks Isaiah Chance was involved in the attempted murder of Charles Jones.
well, that's been what's been suggested up to now, and
No.
am I mistaken? I'm mistaken.
Judge, we wouldn't go into that sort of opinion testimony. We do plan on presenting the physical evidence that ties him to that,
Yeah.
as well as any statements he made through other, but not through the opinion of
Right.
an officer. They have not charged it.
Not relevant to Mr. Murphy and not admissible to Mr. Murphy.
Well, it's a conspiracy charge.
Judge, again, we'll get to that because that's what the supplemental, that's what the supplemental.
Well, that's a separate issue. So
Right,
let's just
supplemental
stay
issue.
Let's just
Yeah,
stay
Judge,
focused, so.
Listen,
Listen, no gang, if the state calls a gang expert, whoever it may be, they're not gonna be able to opine about culpability of anybody who hasn't actually been charged or arrested or proven guilty, so that's not gonna happen.
Okay, because certainly Detective Nieder was very clear when he said that Chance was upset with ATK.
Well, I understand, law
Got it.
enforcement says lots of things in depositions that never come before a jury.
Understood, that's why we want to make sure that that's
Yeah,
covered in a
it's
motion
not.
like this. Judge, in an incident-by-incident review, in addition to the other incidents that are set forth in the motion, but they don't matter anymore, let's take these 6. We believe that it establishes that the state doesn't possess witnesses with firsthand knowledge capable of establishing gang membership, internal group dynamics of the gang, retaliatory decision-making, or coordinated action amongst these groups, part of the reason being that they're hybrid groups, and nobody is accountable for anybody else. And that is clear by the nature of the detective's definition of this type of association.
Sure, and I indicated in my email yesterday that you all would be given 20 minutes each, so I haven't been timing you, Mr. Gonzalez, but
I hope
I'm
you're not,
sure-
Judge. Don't start now.
I am not, but I'm sure the other counsel would like a chance to weigh in, so I'm gonna give you 5 more minutes.
Yes, Judge. Your Honor, when we talk about Hayes and Richardson as it relates to,
The admissibility,
yes, Judge, which is part of this, a large part of this, the severance issue as well as the intertwined evidence. I think that, Hayes and Richardson are co-defendants.
correct?
They were tried together, but with separate juries, notably, and essentially.
Because of a Bruton problem.
Judge, there's no brute problem here, there's no antagonistic
No, I know,
defenses
not in
here.
our case. In Richardson Hayes, there was a Bruton problem, which is why they had 2 separate juries, but the case was tried together.
And Judge, although the evidence is similar as to both of them, I think Hayes is a little more illustrative in its opinion. And essentially, in that case, what I want to make sure the court understands, my position, that this is a feud between PCE and 187. You've already heard, things about that, so you can understand the interrelationship. And essentially, these 2 gangs got sideways at a Kodak Black concert in November of 2015. And essentially, that spawned a street war between them that lasted approximately 76 days. And those are the intertwined evidence that the state admitted over objection in that particular case, which is a far cry from the level of alleged inextricably intertwined evidence in this case.
Well, in the Hayes case in particular, and for the record, we're referring to 338 7th 3rd 1123. In that case, the specific time frame as far as the historical gang evidence that was admitted was November 25 through January of 2016. That was the specific time frame. And I would just note for the record that in the Andrews case, I did allow Detective Nieder to discuss, I believe, the incidents of violence which kicked off in 2023. Like, you had the 2 incidents in the 2018, 2019 timeframe, and then there really appeared to be relatively quiet, and then in 2023, the violence cropped up again. So with regards to Ms. Andrews, I did permit Detective Nieder to testify to the history from the 2023. And I do believe, because Mr. Howard testified, that some evidence regarding the killing of Joe Rod Adams came in because he was actually a witness. So,
Fact evidence as to his involvement in that murder.
right.
Judge, the big difference here is that in Hayes and Richardson, firsthand knowledge, there were multiple witnesses that testified that the defendants were members of gangs, they were members of the same gangs, they interacted with the defendants in this case, Hayes and Richardson. In fact, Mr. Bradford testified to what their street names were. He testified to they were both known as shooters in the gang and had participated in shootings in the past. That he, on many of the photographs that were entered, was able to say, I know that photograph.
Well, I agree. In that case, I don't see, and I'm not sure if the state called a gang expert or not, but in the reported opinion, the history of the gangs came in through gang members, correct?
Yes,
State?
Judge.
Yeah.
Which is the way it should be.
Well, that's why I asked you if gang experts could testify to that, and you said you didn't believe so.
No, Judge, I don't.
Okay,
I-
so I'll hear from the state on why gang experts can testify to that.
And so, Judge, if you, court's read the opinion, you're not gonna give me much more time, you're glaring at me, I get it.
I'm not, for the record, that's not a glare,
I-
Mr. Gonzalez.
I didn't want the record to reflect that.
That is
Did-
it's just a mindful look.
Yeah, Judge, and I didn't want the record to reflect that actually as it was said. If you go through those two cases, with Hayes being a little more illustrative, you can see the 180-degree difference between those cases and these. And one of the major arguments of Mr. Murphy is that in circumstances like this, that's what the state needs. They need a firsthand witness to corroborate. They corroborated the videos that were admitted, the witnesses, the firsthand witnesses. They corroborated the photographs that were entered. They went so far as to be able to corroborate the car that was stolen and used in the murder because Mr. Bradford, the witness, supplied it. They were to the defendants. They were able to corroborate the gun that was used.
And I don't disagree, it's a separate issue, so.
So, Judge, at the end of the day, again, I would rely on the motion and the particularity it sets forth, and essentially tell the court that the state can only establish the connection between the charged act and the prior act by relying on the detectives, in my estimation, I believe buttressed by the case law, improper testimony of lyrical interpretations. We skipped through that part, but it's in the motion, and what somebody thinks something says without it being coded language, without it being a circumstance where this language is used over and over and over and over again, which would allow an expert to testify to it. I do not believe that any of these detectives should be allowed to testify as experts based on the arguments that I've made and also those that are in the motion. I've included their depositions, Judge, which I think are really instructive when they're talking at length about their jobs and what they do and how they do it and how they get their information. I don't think the court has to rely on me. I think it's very clear in the depositions under oath. And finally, Judge, that they are drawing these clues from songs that are released by artists that are commercially viable. They can't establish gang affiliation other than maybe by 874 criteria, which I think is different than testimony that would allow this evidence to be relevant and admissible, and especially to show that there's a motive for these killings. It should be done with competent, non-hearsay evidence, and those prior acts are rendered irrelevant when they're not done that way.
Okay, very good. Okay, let's see, Mr. Sonardi, do you have a motion as it relates to Davion Murphy on this topic? Or have you adopted, Mr. Gonzalez's?
Correct. As to the 6 prior acts that the state intends to introduce, both as to Mr. Rashad Murphy and Davion Murphy, we will adopt the arguments of Mr. Gonzalez on behalf of Rashad Murphy, and also add that we can establish that Mr. Davion Murphy was basically incarcerated either in the Jacksonville County Jail and Florida State Prison from 1916 until almost till January 2023.
Do you mean 2016? You
Yes.
said 1916.
I apologize, Judge.
2016.
2016 until January 2023. The same argument as provided by Mr. Gonzalez on behalf of Rashad Murphy. Mr. Davion Murphy is not alleged to be a suspect or anything in either of the 6 prior acts that the state intends to introduce. I concur also in the evidence that's available to even establish that Mr. Davion Murphy is in fact even a gang member of 1200. Again, he was incarcerated, the 5-year window under the statute that expired. He is at most an associate. So again, we submit that contrary to the state's position, that introduction of those 6 prior acts as it applies to Davion Murphy would be so highly prejudicial as to not to overcome its probative value. We would ask the court, as to Davion Murphy, to exclude that testimony.
Okay. And Sean Gathright, defendant's motion in limine to exclude collateral evidence. Mr. Wise.
Your Honor, I guess, before I begin, maybe for a point of clarification, there are, as you've heard, casings found in Mr. Gathwright's home that not even matches to 2 prior incidents. I think the only one that's of the 6 we've discussed is the prior Charles Jones shooting. So
Correct.
I don't know if the state it sounds like the state may not be seeking to admit evidence regarding these other 2 alleged incidents, one of which I don't even think they know what or who the target of was. But could I just ask if do I need to address the Byron Walker incident and this unknown shooting from 2022?
We can speak to that. All the knife-in correlations to the other shootings from the traffic stop as well as from the safe of Mr. Gathwright's house, we are not going into. The only ones that we are going into were the ones that were actually confirmed, not just knife-in, but FDLE
Right.
matches
For
to.
Mr. Jones.
Correct, the
Okay.
attempted murder, and then to our case
Yeah.
here.
Okay, so that streamlines it a little bit.
Okay.
So, Your Honor, Mr. Gathwright's a little bit differently situated because he's clearly not a gang member. No one's even alleged that he was a gang member. As you heard from all of the alleged experts who testified, I guess it was last week, none of them had even heard of his name prior to being contacted by Detective Ramos. The only connection that the state has as to Mr. Gathwright is this allegation that he was friends with Isaiah Chance. And even that, I think, is pretty speculative. There clearly were communications between Mr. Gathwright and Chance, but I believe there's some thought that they must have been best friends, and I don't even think there's evidence to support that. The only thing connecting Mr. Gathwright to these gangs is his communication with Chance, and quite frankly, I think that the connection between Mr. Chance and the gangs is pretty speculative as it is, but that's the only connection. So he's clearly not a gang member, and I don't believe he can even really qualify as a gang associate, just based on the fact that he's communicating with Chance. But that.
Well, the state has not identified,
No.
and then, and as far as I can tell, they're not seeking to prove that Mr. Gathright is a criminal gang member or associate, just a member of a conspiracy involving other gang members.
Judge, we're not approving an enhancement against him, but he certainly qualifies as an associate by the meaning of the statute with his association with Isaiah Chance. And Judge, we believe it's the jury's decision to ultimately find who is an associate and who is a member.
Okay, all right.
And again, Judge, if that's the case, then basically everyone Mr. Chance has ever talked to is a gang associate. I know that's probably a separate motion, but when we talk about relevance of all these other prior gang activities, the only connection, again, to Mr. Gathright is the fact that he's communicated with Isaiah Chance. Talking about each one specifically, the Gerard Adams incident, Mr. Gathright would have been 13 years old, I believe, when that took place. The Bibby Gaynor incident, he would have been, I believe, 14 years old. There's nothing connecting him in any way whatsoever to the Jaquan Pickens incident. Same with the Jacoby Beals. And the Antonio Tilly. The only connection, again, with the Charles Jones incident that takes place on the same date is the casings that are found in the Niven matches. But as you heard from the detectives last week, Mr. Gethard was not even on their radar in that case until the casings came back. So it's really just the mere fact that these casings are in the house. There's no explanation as to how they got there or whatnot. And there are, by the way, as you heard, there's a substantial amount of firearms and firearms evidence within the house that's searched. So that, Your Honor, I believe the relevance, whatever relevance would have all these incidences, and really the only one as to Mr. Gethard that could have any relevance whatsoever is the Charles Jones shooting. But the undue prejudice would far outweigh whatever relevance that evidence might have. I cite two cases in my memorandum that I think are remarkably similar to what we're dealing with here. And looking back now, I probably should have referenced them with regards to the severance issue too, but it's Thomas and Gilly. And it doesn't appear that these were cases that involved gang issues, but it was very similar in that there are prior shooting incidents involving allegedly rival drug dealers and then their associates. Maybe they were connected with gangs, but it's taking the gang word out of it. I think it's really the same exact situation we're dealing with here. There were prior shootings, and then someone is killed in one of these prior shootings, and then there's a shooting that takes place of this prior victim's associates, and then a bystander is killed. So when the defendants were being charged with the shooting of the bystander, and Gilly, and it's not clear why he was severed, but he's severed and tried separately, the state brings in evidence of all these prior shootings, and that goes up on appeal after everyone's convicted. And in both cases, the second DCA says these instances were not necessary to describe the shooting. It was a pretty straightforward, the allegations of the crime they were actually being tried for were pretty straightforward. The courts found they did not need to get into these prior shootings to describe what took place. And it became, as I fear will happen here, a feature of the trial. And for those reasons, both of those defendants' convictions were reversed. And again, I'm not sure why they were severed, but it would appear that Gilly may not have had involvement in these prior shootings. I don't know if that's the case or not, but for whatever reason, he was severed, and it appears, based on my reading of those two cases, it may have been for that reason. But all this prior evidence comes in both cases it becomes a feature, and in both cases, the convictions are reversed. And I think it's really the same exact situation we're dealing with here, especially as to Mr. Gathright, because he really has no legitimate connection to any of these gangs.
Okay, very good, thank you.
Judge, we would adopt that argument on behalf of Mr. Rashad Murphy as we would all other defendants' arguments.
Sure.
Same here on behalf of David and Murphy, Your Honor.
All right, very good. Mr. Petratus?
Thank you, Your Honor. And we filed our own motion, but we would adopt the motions of Mr. Gonzalez and Mr. Wise in their arguments, and I'll try not to be too repetitive.
Okay, and this is Isaiah Chance's. It's titled Defendant's Motion to Exclude Inextricably Intertwined Evidence at Trial.
Yes, Your Honor.
Okay,
And
go
just to
ahead.
go over the murders, again, very briefly, we have one from 6 years ago, the Spaz shooting, which is a alleged 1200, not ATK, of which Mr. Chance is purportedly a member of. And I think it's important to know that Robert Howard, who's, as the court is aware, is going to testify, at his deposition denied being a gang member of 6 Block. So I understand that they're going to try to get it a different way, but they're going to get someone here, like Mr. Gonzalez stated in the Richardson-Hayes case, but this time this person's going to say, no, I wasn't a member of 6 Block. Then we have a 6-month gap. We have the Gaynor shooting. That is alleged, well, it's not alleged, it was a charge of ATK. The next 4 that all occur in 2023 are all unsolved. And no one is going to testify as that was involved in any of those shootings. You're going to have no gang members to come here and testify to that. In the Pickens, in the state's motion, it says ATK is believed to be involved, Again, it needs to go back to Detective Nieder. And the court asked, the court said you can't opine on someone who committed a crime that we don't have a conviction. And I would argue that you can't opine the gang affiliation of a person who we don't know committed the crime. You can't, it's another step that requires Detective Nieder to opine. Detective Nieder, in his deposition, stated he gets his info mainly from social media. He does talk to gang members, but he gets general information, not specific information for them. They are not confessing to crimes for him. That's not what's happening. He's just getting general background information from them. And I would argue that's not enough to come in and tell us who committed these crimes and say it's ATK, it's 1,200. The Beale shooting is alleged to involve 1,200, not ATK, and as Mr. Gonzalez stated, the last Charles Jones shooting has not involved a gang at all. They're gonna say that Mr. Gathright is an associate, but again, that involves being friends with one gang member at the most. In Richardson, again, it was 76 days, and the court said it's a continuation and consequence of preceding events. And I'm gonna argue that 6 years and 5 years ago, there's not preceding events to this crime. I would argue even, we have an 8-month gap between the last event in this historical gang war and this shooting. The court mentioned Griffin in the Richardson case. It said, to prove its case, the state is entitled to present evidence which paints an accurate picture of the events surrounding these crimes charged, surrounding these crimes. In the Richardson case, again, 76 days, that happened one after another in a 2.5-month period. That is not what we have here. Richardson, one of the reasons they allowed it in, from my reading, was that they wanted to get the state why these victims were in fact the victims. We had a toddler and we had two elderly, or maybe not two, but an elderly grandmother and a middle-aged lady, and they wanted to explain how they could be the victims in that. But that's not the case here. We have someone, Charles Jones, who is not a random civilian. There's going to be gang evidence presented about Mr. Jones. There's going to be gang evidence presented about all the co-defendants. There's going to be evidence of their involvement in the gang, testimony of a rivalry between ATK 1200 and 6 Block, all without the need to mention any of these prior shootings. The motive can be clear through the state's evidence without having to mention any of these shootings, and I think that's what the court should require. One other thing that hasn't been mentioned is these cases mentioned it cannot be a feature of the trial.
Correct.
And I find it hard to believe that if the state puts on 3 gang experts and then all the witnesses, and I'm gonna use witnesses in quotes, to come in here and testify to show the other murders 6 times, that's days. It's
Well, yeah,
days of testimony.
no, and I do just have a little experience because the Andrews case, that's not what happened. Detective Nieder testified in his capacity as a gang expert, just historically, as far as the history of the gang violence. The state did not bring in, my recollection, any witnesses other than Mr. Howard, who was a victim in this case, so.
Well, we're talking, and I understand that, but I think that's gonna be different in this case because I think they're gonna try to bring in more.
Well, we'll see. You're right, it cannot become a feature of the trial.
And I find, I understand, but I just find it hard to believe it will not end up being a feature of the trial if we're talking about 6 other murders. I don't know if that's exactly what happened in the other case, but everything else that I would get to is either in my motion or has been stated by the co-counsel, so that's all I have now.
Okay, very good. All right, state any quick rebuttal just as to the 6 previous incidents that the state wishes to introduce
Judge,
into evidence.
Judge, we are certainly not going to make it a feature of the trial. We do plan on calling one detective to really go over the historical gang war, so it will not be a feature. However, we are going to add
And
some.
who is that gonna be, do you know?
Judge, we believe it's gonna be Detective Nieders. The other 2 are listed because we still have to show gang enhancements and stuff of that nature, and I do believe their expertise adds to.
Sure, that's a separate issue.
That's a
And
separate issue.
in the indictment, the state did specifically allege that Isaiah Chance, Rashad Murphy, and Davion Murphy were either criminal gang members or associates.
That is correct, Judge.
Okay, but not Mr. Gathright.
We did not, Judge. But Judge, there are going to be, I know that Mr. Gonzalez has kept saying, like, this is all based on hearsay. That is not true. There were some additional witnesses that were listed that were involved in those 6 other cases. And again, it's not gonna be a feature. What I plan to do, Judge, is to have either a first responder just testify briefly within 2 to 5 minutes that they responded to that homicide, who the victim was, and then the gang expert is later going to connect up that that victim was actually a member of one of these gangs. And then the next day, these are real things, real facts, real deaths that did happen, and the victim of one gang is killed, and then the next day, a victim of the opposing gang is killed. And so, Judge, this jury should have a real, true, accurate picture of the very gang war that is going on. And these incidents also, even though they exceed the time frame, I understand what they're saying about Richardson and Hayes, the particular of that gang war, the escalation of violence, but it was 6 shootings that occurred back and forth, happened in a very short period of time. It's different in this case, but the incidences that we have selected are relevant to this case, and some of the relevance doesn't even have to do with any of them. It has to do with the victim and as a consequence with all of them, because the victim in this case, the motive for, and obviously one of the rap videos that we're going to introduce, and the motive for why they did not like him and were very upset and angry enough to kill him is his drill rap videos. And certainly that also goes to our gang experts' testimony. They do have specialized knowledge. This is something that they all have years of experience in this gang unit where they are monitoring this activity on social media, and it's not hearsay. They are visually monitoring it, and they see a death happen, and then within 2 or 3 days, sometimes within the very next day, there is a video that is posted detailing and ditching the person who was just killed.
Well,
All of that.
desecrating someone's gravesite's pretty provocative behavior.
Yes, Judge. All of that is part of this gang war back and forth, and the jury needs to have an accurate view. And some of this is highly prejudicial towards the victim, because the victim is out there doing the same thing, which makes him a target. And he is dishing and disrespecting the close members, people that we can connect to them, either through their wearing necklaces. They have posted their own videos, Judge. All of that is relevant to this case and is inextricably intertwined and shows why he was targeted and why he was killed. And Judge, when you talk about the hearsay, that is why we have listed either a first responder or the detective. Detective Nieder actually responded to some of those incidents. So we are not gonna call 6 witnesses, but certainly the ones that he did not respond to, we have just listed a first responder, or we have listed the detective who actually went on scene and can say, on this day I responded, this person was killed, and his name, and then we will go to our detective to say that that is a confirmed member of 1200, or that is a confirmed member of 6 Block, or Bully Gang, which is a subset of 6 Block. So this by no means is going to be a feature of the case. And all of these detectives, even within the depositions, were honest and said they didn't know that that was an unsolved case. But certainly after a case where a victim is identified as a gang member and the opposing group then posts a video claiming credit, making fun of that victim's death the very next week or within a short time period, certainly that is a specialized knowledge, and it goes to the very heart of this case and the very motive why our victim was killed. And the probative value of motive, wanting to kill the victim, has a high value, and it is not going to ever be outweighed by the prejudicial nature. And that is what Harris and Richardson really explain when it let in 6 other shootings into a case, because it gave the jury an accurate depiction of the war, the escalation of this gang war, which led to those 3 people being shot and a child being killed. And so, Judge, that is what we have here. The prejudicial nature is not so significant. Some of these deaths are from our victim side killing the other side. The ones that are targeted, they are not charged with, and none of the detectives said, with the exception of the attempted murder, and we know we're not going to elicit what their personal opinion may be, but certainly there is going to be physical evidence that ties this as part of the conspiracy, that they tried to kill him before and they weren't able to do it. So certainly all of those incidents, even though we go outside of that time period in Richardson and Hayes, are still relevant, they're inextricably intertwined, and those specific cases are tied to our victim and the defendants in this case as being relevant, and again, highlight the animosity between these two groups. They're making fun of people that are killed back and forth. Some of these shootings within the very next day, including the attempted murder of Charles Jones, was done the very next day after members of the opposing side, one of their members was shot. And so that is the state's argument, that this is all relevant. It is not going to be a feature of the case, but it goes to the very heart of all of this group's motive to kill Charles Jones, the victim in this case.
Okay. Okay, so in the Hayes case, the court stated as follows, and get the page number. At page 1130 of that opinion, in establishing its case, the state is entitled to present evidence which paints an accurate picture of the events surrounding the crime charged, but cannot make the evidence of other crimes the feature of the trial or introduce evidence solely for the purpose of showing bad character or propensity. Collateral crime evidence, regardless of its status as similar or dissimilar fact evidence, is admissible if it is inextricably intertwined with the charged crime. Collateral crime evidence is inextricably intertwined if it is necessary to, 1, adequately describe the deed, 2, provide an intelligent account of the crimes charged, 3, establish the entire context out of which the charged crimes arose, or 4, adequately describe the events leading up to the charged crimes. Additionally, evidence is admissible if the prior incidents are relevant to several material issues, including motive, intent, and identity. So based upon the facts and the motions and the arguments of counsel, I am going to find that the 6 identified incidents in the state's motion in limine are inextricably intertwined, and they are relevant to motive, intent, and identity, okay? So those, just as a threshold, those 6 incidents are admissible in this case. All right, I'm gonna take a recess, and so, actually, before I do that, so as it relates to the state's motion in limine regarding those 6 incidents, I'm gonna grant it. Let me just take a look here. I'm going to grant the motion, but I'm going to reserve ruling regarding the introduction of any videos, any rap videos that the state seeks to introduce. And once the state does their evidence list, as far as what they're actually going to attempt to introduce, then if there are further objections as to any individual videos, defense can renew their objection and I'll rule, okay? All right, so as to Isaiah Chance's motion to exclude inextricably intertwined evidence at trial, that motion is denied. However, defense, as I indicated, can raise contemporaneous objections to any individual items of evidence. And with regards to Sean Gathwright's motion in limine to exclude collateral evidence, that is denied. However, again, defense has the ability.
Well, and can I add, because I actually specifically addressed those other 2 instances, the state is not seeking to evict, so could that be?
Yes, it's denied as to the 6 incidents that are in the state's motion that I've articulated here today. It would be granted to any other incidents that are not part of the 6, and that goes as to all defendants. okay? So we're just talking, so it's denied in part and granted in part. Thank you for that clarification, Mr. Wise. And then as to Rashad Murphy's second motion in limine, there were a number of items, Mr. Gonzalez, that you raised. At this point, it's denied in part only as to the 6 previous incidents that I articulated here today. Okay? All right, we'll take a break, and I'll be back at 10:50.
Court's in recess.
Going to be objections. What I want to handle those after the state has identified which videos they're going to actually seek to admit, and you all have had a chance to review them, and then I will handle specific objections after that happens. Okay? So I'll reserve ruling on specific objections to any specific videos that the state intends to seek. Or, for that matter, any other evidence related to these 6 prior incidents that I am allowing into evidence, okay? All right, so there are a couple of, let's see, a couple other motions that were filed related to the gang issue. I know that Mr. Gonzalez, you have defendant's third motion in limine as to gang affiliation, gang identification, gang charts. Ready to discuss that?
Yes, Judge.
Okay.
Judge, this motion does have some dovetail effect.
Okay.
As it relates to some of the court's prior testimony, argument, and rulings. Essentially, the motion seeks to prohibit the admission of opinion testimony, again, identifying an individual as a member or an affiliate of a particular gang, defined in 874.03. Certainly, as the court knows, one of the things that the state intends on doing is admitting gang charts that would include victims of prior uncharged incidents, and probably seeking testimony as to those people and their deaths.
And state, are you actually intending to offer these charts into evidence?
Judge, we are gonna use them as demonstrative exhibits.
Okay.
Certainly the same issue, whether they come into evidence or not, the jury obviously is going to see them, hear testimony about them, and the same limine issue, I believe, is still intact, and that is that I don't know and I can't anticipate the state's testimony. That's what these motions obviously are for.
Right.
But many or some of those individuals, whether they are killed by some other member of that or another gang, I
And,
think.
I'm sorry, and are the charts that you're going to intend to use as a demonstrative, are those prepared yet, or they're going to be?
Yes, Judge.
They are prepared.
And they're exhibits in the motion, Judge, too.
Okay.
And essentially, they include a bunch of people that are dead. And not only people that are no longer with us in the 6 incidents,
Right.
but otherwise.
Yeah. Why do you need the chart?
Judge, I think it's a demonstrative aid, and there are a lot of gang members that are in the 6 incidents or in the videos, or there are actually other pieces of evidence that are either from the defendant's Instagram accounts or stuff of that nature, Judge, so that places them on the chart so that it can assist the jury to keep track of who is with whose group.
Is the state going to elicit testimony as to each one of those individuals as to what their gang criteria is, how they are documented as a gang member, under what circumstances? Because, again, a picture of someone.
Right.
Judge, no, and we may further modify and take some people out, Judge.
Yeah, so what I'm gonna do, I'm gonna reserve ruling on the gang chart, state you're not gonna use it in opening, okay? And, you need to be very conservative, even though it's a demonstrative aid, you need to be very conservative in who you put on that chart.
Yes, Judge.
And honestly, that, to me, this is more of a discussion about whether or not, you can use it in closing arguments, depending upon what the evidence is, okay?
Yes,
So,
Judge.
that's my initial thought on the gang charts.
And so the court's just gonna reserve until we see another exhibit?
I'm
and-
gonna reserve ruling, but I am gonna specifically find that the state cannot use that demonstrative in openings. Okay, so we just need to see what the evidence is, and then we'll, as we get to closings, we'll see if there's further objection, then I'll let you know if they can use it as a demonstrative in their closing argument.
Judge, the next area of the motion is the actual documentation of Mr. Murphy, of Rashad Murphy. The court heard testimony from Detective Griffin, who is allegedly the person who follows and has specialized knowledge as to 1200, and documented Mr. Murphy as a 1200 gang member a month after this shooting took place. He was not previously documented as a gang member, only having done so July 23rd, a month after this particular murder, which is curious in and of itself. Now, granted, the position is, pursuant to testimony, is, well, you know, we can document somebody anytime we want. You know, we could have criteria for them in 1921 and not document them until 1924. I said, well, even if you've already got criteria under the statute, isn't that the point of this? To have everybody know, law enforcement and other related people that have access to the fact that somebody's a gang member? Well, yes, but there is no timeline. Everybody does it differently. Everybody has their own style. Some people document after 2 criteria, some 3, some 4. But the gravamen of the situation at this particular juncture is, number one, Mr. Murphy was documented as a gang member a month after this shooting took place. Secondly, although I recognize there is statutory criteria that document somebody as a gang member, and certainly I can take issue all I'd like as it relates to that criteria and what it means in and of itself, the one thing that is undeniable is that in order, I believe, for testimony to be heard by a witness, in particular a gang investigator, that testimony still can't be hearsay. And it's the same admission standards as it would be any other type of evidence. And in this particular case, Mr. Murphy is documented a month after the shooting because there's been a documented, reliable informant that identifies him, A. B, he adopts the use of hand signs. C, he associates with one or more known criminal gang members. And D, he's observed in the company of one or more gang member 4 times or more. Again, it's a statute. I'm halfway in shock, but it's a statute. And essentially, the first category, that being that Mr. Murphy is subject to a reliable informant, that is really not the case. It's a reliable documented informant. The informants, 2 of them, that Detective Griffin, or not even Detective Griffin, by the way, Judge, not Detective Griffin, somebody before Detective Griffin, documents Mr. Murphy with is somebody who stopped for a possession of marijuana misdemeanor. They have a list of people when they're doing whatever investigation they're doing on that misdemeanor of marijuana. Hey, do you know so-and-so, 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 and so-and-so, and Rashad Murphy, and are any of them gang members? Yeah, maybe number 3, number 5, number 7, and Rashad Murphy are gang members. So that is supposed to be check, an indicator of his documentation as a gang member with no name, no date, no incident as it relates to the stop, doesn't tell us where, doesn't tell us why Mr. Murphy is a gang member, It is that statement from a stranger under those circumstances that is going to be testified to as Mr. Murphy's gang criteria number 1. That happens twice. Same circumstance. And I won't go into the second set of facts, but extremely similar with no direct evidence as to anything other than it happened. Secondly, the second criteria, I believe, lacks, foundation and is entirely speculative. This particular circumstance happens where Detective Griffin says, yeah, I saw Rashad Murphy give a hand signal. And he points and I said, what is the hand signal? He says, well, I can't really do it. I mean, I can't really tell you exactly, how it's done, but it's in a video. So we can look at a video, and I'm not a gang investigator, and certainly Detective Griffin says, yeah, well, hey, you look at that. But there is no specific movement in hands or presenting a signal or a handshake that I believe is shown within that video. That's criteria number 2. Third criteria is that Mr. Murphy is allegedly identified as a person depicted in a music video, not one of the ones that we're talking about. And it wouldn't be Detective Griffin that can identify him based on having looked at that video, because he hasn't had and didn't have any interaction with Mr. Murphy. It would be something told to him by another detective. And on top of that, as it relates to identification, I think the law is clear that someone can't identify someone based on a prior interaction with them, when in fact the jury can look at a video, if that's what the state's objective is, and decide whether or not it's Mr. Murphy or it's not Mr. Murphy. But the way that it dovetails into this argument is, it is a criteria which the state is going to rely on to be able to provide the testimony that Mr. Murphy is a gang member, which, as the court certainly knows by now, that is a critical statement to be made for the jury's consideration, considering the totality of the evidence here as the court has ruled to be admitted. So to that extent, I would just argue that, first, a witness cannot testify to a legal conclusion that an individual is a statutory gang member because it is based on hearsay evidence. And we still have to go back to the evidentiary foundation as it relates to testimony at a trial, and I believe that the case law would buttress that. There's a distinction between the state offering fact-based testimony for which a jury can determine whether a legal element is satisfied, and there's a difference between whether it's opinion testimony based on maybe not even what that detective did, but what a detective before him did. And I would suggest to the court that that's impermissible, and I think that's what the state intends in this case. It's going to present evidence that is, and it can't present something that is a statutory conclusion that's cloaked in some type of official authority.
Well, you're saying that the detectives, if they testify as a quote-unquote gang expert, that they can't tell the jury that any of the defendants meet the statutory definition of criminal gang or criminal gang-related activity, correct?
And not especially as it relates to Mr. Murphy. I don't know about in general, based on what the evidence is and based on what they're going to testify to. I don't believe the state can rely on hearsay to establish gang membership, and that I think is reflected in the case law in the Fossum case and in the McGill case. And essentially in Fossum, the state found that recognizing that although experts may rely on inadmissible evidence, that it may not be used as a conduit for evidence and may not testify regarding their consultation with others. So that is, I think, an issue in McGill, holding that the trial court's reliance on hearsay testimony regarding a defendant's gang affiliation in rendering sentence, this is a sentencing case.
Do you want McGill?
Yes.
Yeah.
It's a sentencing case. Require reversal and new sentencing hearing. And although I understand that certainly evidence that might be admissible in sentencing may have a different admissibility standard as it relates to a trial, usually admission of sentencing evidence is broad and more easily attained than what would be allowed in a trial.
Well,
So-
in that case, I guess at sentencing, the judge, it says the trial judge improperly relied upon unsubstantiated allegations of McGill's gang involvement in the form of objected to hearsay from a police detective.
Correct.
Once the truth of the hearsay information presented at the sentencing hearing was specifically disputed, the state was obligated to carry its burden of corroborating the accuracy of the information. Okay.
Correct.
So hearsay, it's admissible. You would concede that hearsay is admissible in an expert opinion, correct?
Well, as long as it is relevant and as long as it is within the bounds of the rule.
And has some indicia of trustworthiness?
That's correct. Judge, as it relates to identification of the defendant through music videos, we're gonna hold off on that. The court has,
Yes, I really just would prefer that we not talk in the abstract, and that when it comes time for me to rule on those specific objections, that we have the actual exhibit, so that way I can look at it if need be, so.
Judge, understood. Admitting improper opinion testimony, in this particular case, gang affiliation, is even more uniquely inflammatory. Now, granted, evidence that you don't like, or evidence that may, in every case, there's gonna be prejudicial evidence, that's the nature of a trial. But in this particular case, in my opinion, it's gonna invite the jury to associate potentially Mr. Murphy with other individuals that may have, and may be properly designated as gang members. I can't tell you that. Counsel, if they choose to, are gonna have to argue individually about the criteria used and the evidence used in order to make that designation. I can only speak as it relates to Mr. Murphy, but it also has a substantial likelihood, again, of a spillover effect as it relates to his association with anyone else involved in the case. Concluding, Judge, I'm not suggesting to the court that admissible factual evidence related to gang affiliation be excluded. What I'm suggesting is that in this case, normally I would say witnesses, but the only witnesses in this case that are going to talk about anything in terms of Mr. Murphy's gang affiliation or involvement with others are going to be law enforcement officers that that relying on hearsay to the extent that they are, and in addition to substantive interpretation, which that's part of the motion, and with particularity that you'll read with regard to those lyrics in other motions that I've drafted, and improper opinion identification that establishes that classification, its prejudice is outweighed by its probative value if it's even relevant. I am suggesting to the court that the motion limit be granted as it relates to testimony from detectives that offer legal conclusions that an individual qualifies as a statutory gang member based on the means and manner upon which they gained that information, and not providing the foundation for its admissibility. Now, it would be a different story if we could cross-examine a detective regarding a report that was written where so-and-so on a particular day, based on this particular knowledge, told us that Rashad Murphy was a gang member. Okay, that may be hearsay, but it would indicate to us the specificity that would allow us to rely on that opinion. And we will not find a single instance as it relates to Mr. Murphy, and I might even suggest some of the other defendants, whereby a detective is gonna tell us when something took place, who it took place with, where exactly it happened, other than to tell us, we stopped somebody for a misdemeanor possession of marijuana, we gave him a list of people, and he ticked off the number, however many number that might have been, based on what the list was. He's a gang member, he's a gang member, he's a gang member. That's it. And when I asked about, well, was there any other particularized information that was given? And the answer was no, it was general information. So to that extent, Judge, I believe that it should be prohibited in limine, and certainly that would extend to hearsay based gang classification testimony, as I've just talked about. It's improper, and I believe it should be prohibited.
Okay, very good, thank you. State, what's your response?
Judge, pursuant to statute 874, law enforcement is permitted to utilize a reliable, documented informant statements regarding each of the defendants' gang affiliation. In addition to that evidence in this case that we have for Rashad Murphy and his affiliation to 1200, we do have several, at least 3 music videos that were listed in discovery. We received notices on those music videos of our intent to rely upon them and the contents therein. Those were certified and provided to the defense as well. In each of those videos, the defendant is meeting several of the other criteria, of which obviously the witnesses are permitted to testify about their opinion as to who is depicted in those videos, because they're being listed as experts. They're certainly in a better position when they're viewing those videos to determine who is depicted in them. The defendant is, in fact, in many of the screenshots that I have, and I can show the court, I know the court asked for specific examples, but utilizing hand signs which have been identified by law enforcement as those meaning that the defendant met the criteria. Is the court interested in actually seeing those today, or did you want to wait on that? I know there are kind of a blend of arguments being made with this particular motion in limine, so I'm not sure what the court.
Well, at this point, I'm just going to broadly rule on the motion in limine, and then once the state has again identified all of the exhibits they intend to introduce, we can revisit if there are specific objections to any of those identified items of evidence.
Yes, Your Honor.
So we're just kind of talking generally at this point.
I will say that there is direct evidence of the other factors that are utilized or testified to by the detectives which deem the defendant, Rashad Murphy, to be a gang member. That is in at least 3 of the music videos. He is utilizing signs, being depicted in those videos with other gang members, and certainly as gang experts, I'm not getting into that argument, they're permitted to testify about those observations that are being made, and also we have the videos and screenshots from those videos which depict the same. Also, the defendant's correlation with other gang members is documented in more than just those music videos. So in addition to the firearms and gang signs that are used in those, he had been stopped with other gang members. Those stops were documented, and law enforcement relied upon the information that was retained in those results as well. Law enforcement themselves have testified that they directly saw the defendant utilizing several of the accounts that they saw evidence of gang activity on. So there's certainly a sufficient amount of direct evidence. I understand that the argument from defense is being looped into this one element from the gang statute that a reliable informant gave a statement to law enforcement, but there are several items of direct evidence, including those music videos, the stops, the defendant's use of gang signs, that the state intends to rely on to establish his actual gang membership. That being said, I want to just draw a distinction between the agency's documentation of each of the defendants as gang members, and that being separate and apart from whether they meet the statutory criteria and what the state has to prove at trial as far as whether in meeting that statutory criteria the crime was committed in furtherance or in progression of the gang's objectives. So I understand, again, the defense's arguments regarding the dates and times of the documentation, but essentially it's the state's burden to prove that these things were met at the time that the crime occurred, not what each agency did.
And what's your position on your law enforcement witnesses being able to tell the jury that in their opinion, any one of these defendants is a criminal gang member or associate? Is that not invading the province of the fact finder?
I believe they can testify as to each of they're gonna testify that they have documented several items of
Sure,
evidence
they're
which are
gonna testify to the statutory factors.
Yes.
Correct, and in there, and what supports, the statutory factors, but as far as the ultimate conclusion, isn't that ultimately the jury's decision to make?
I think the conclusion that the witnesses will make are that they are documented with the Jacksonville Sheriff's Office as a member of 1200, documented with the Jacksonville Sheriff's Office as a member of 6 Block, instead of making a general conclusion that they are documented gang members that killed Charles Jones in furtherance of the gang's objectives.
Okay,
Two separate things in the state's opinion.
okay. All right,
Judge, quick rebuttal. Were you done, Ms. Hoover?
No, yes, thank you.
Judge, number one, this confidential informant is neither documented nor reliable, so I would take issue with that representation. At least I understand it's coming straight from the criteria under the statute, but in this particular case, neither of those things are actually accurate. Second of all, I don't believe that any of these detectives are in a better position to look at a still shot, okay, of a video and look at Mr. Murphy and make a determination whether or not that's him.
well, maybe yes, maybe no, and again, that's gonna be, very, item of evidence specific.
Yes, Judge.
Okay.
And I also asked the court to reserve ruling as it relates to whether or not any of the music videos would indicate or show Mr. Murphy utilizing gang signs.
Okay. Okay. All right. So as to the defendant Rashad Murphy's third motion in limine, I've already ruled on the gang charts. With regards to gang affiliation and gang identification, I'm gonna deny the motion, but again, generally speaking, Mr. Gonzalez, you can always raise contemporaneous objections at the time the testimony's coming in as to any particular factors that law enforcement's gonna rely upon. And with regards to the ultimate finding, whether or not these defendants, any of them, meet the statutory definition, that's not for law enforcement to opine or render an opinion from in front of the jury, because that's gonna be a fact that the jury has to find as to the 3 defendants where the state is seeking or has notified those defendants that they're seeking to have them identified as a criminal gang member or associate.
Judge, in clarification, are you saying that the state's prohibited from eliciting testimony from the detectives that Mr. Murphy has been documented as a gang member from 1200?
At this point, yes, I am, okay? So law enforcement can testify as to any and all of the factors, and law enforcement, for example, Detective Nieder can tell the jury there is a statute that is utilized, and these are the factors, and this is the evidence that supports the factors, but that ultimate conclusion is for the jury to make, okay?
Your Honor, Nick Sonardi on behalf of Davion Murphy. Obviously, we're going to join in on the motion to exclude any designation of Davion Murphy as either an associate or a gang member. My understanding as it applies to Mr. Davion Murphy, I've been provided a photograph from the internet that goes back to 2016 that shows Mr. Davion Murphy with Noah Williams and Reginald Williams, who I believe were documented 1,200 members. That's the only thing I'm aware of. Mr. Davion Murphy is not depicted in any music videos that I'm aware of. The only gang sign that I am aware of that alleges that Mr. Davion Murphy is a member of any gang is at the interview that was conducted in Jacksonville, where he is singing to one of the rap songs, and during the course of that singing, allegedly makes instantaneously a gang sign. And again, he is in no social media that I'm aware of. The designation by law enforcement that Davion Murphy is allegedly a gang member, a gang associate, occurs after the homicide here in Tampa. He is not even known to Detective Griffin, who was the gang detective for the 1200 gang, as I recall his testimony. So we would also ask the court to exclude Mr. Davion Murphy designation as even a gang associate.
Okay, thank you. I will deny that motion, but again, the same ruling applies as to your client as it does to Rashad Murphy. Okay? Okay, and, let's see here. I know that Mr. Gathright filed a motion in limine to preclude any reference to the defendant as a criminal gang member or associate. You want to discuss that one further, Mr. Wise?
I don't know that it's necessary, Your Honor. I think we kind of addressed it earlier. I mean, it's almost like he just dropped in one day. No one in Jacksonville knew who he was. There was no connection. The only alleged connection is apparently talking to Mr.
Well,
Chance.
State, are you going to seek to to elicit any reference or designation as Mr. Gathright as a criminal gang associate?
Judge, no, now that, Judge, we did not list him under the enhancement in the indictment.
Okay, so that motion's granted.
Thank you.
Okay? Okay, let's see. Okay, let me go to my next pile, motions.
Judge, did, Judge, did you rule on Rashad Murphy's first motion in limine regarding Ghost 187? Because I thought.
No.
Okay.
Nope. You wanna do that one next?
Yes, Judge.
Okay. Mr. Gonzalez, you're
Judge,
up again.
Is there one we might be able to do in the interim so I can catch up?
Yeah, sure. Let's do, I tell you what, eeny, meeny, miny, mo. Let's go with, Davion Murphy's motion to, C4 motion to dismiss.
Well, Your Honor, Nick Snarty for the record. We did obviously file a C4 motion, and concisely the evidence, although the state did file a traverse, the evidence as it applies to Davion Murphy is basically alleged that phone records tracked what's supposedly his phone from Jacksonville to Tampa prior to June, I believe it's 22nd. He is then seen supposedly in a vehicle at a McDonald's going through the drive-through on June 23rd. The next time they allege that Mr. Murphy, Davion Murphy is seen is in a security video at the Airbnb. There is no phone records that place Mr. Davion Murphy either at the clubs that are allegedly visited prior to the homicide or at the Home 2 suites. The next time that Mr. Murphy, Davion Murphy is allegedly located, or again, supposedly phone records going from Tampa to Jacksonville and the license plate readers. He is not identified at the scene of the homicides, and that is substantially the state's case, and that's what we're alleging. That's insufficient as a matter of law to survive a directed verdict.
Okay, thank you. State, any argument? I know you filed a traverse. Anything
Judge,
further?
we rely on our traverse.
Okay. That motion will be denied. Okay. Let's see, what else do I have over here? All right, Davion Murphy's motion in limine to exclude the office of the state attorney from indicating or intimating that Davion Murphy is affiliated with ATK or 1200 Block or any other gang.
I believe that goes along, Deborah Toomey on behalf of Davion Murphy, that goes along with the discussions and arguments by all counsel thus far
Okay.
So I would rely on those arguments and
Okay.
the court's previous
All right.
statements regarding this.
So again, the motion will be denied, however, defense reserves the right to make specific objections to specific items of evidence or testimony, all right? But the motion is denied. Okay. All right, let's see, Mr. Chance has a request for judicial notice. And essentially, you're asking me to take judicial notice of the fact that Ms. Andrews was convicted of manslaughter on October 31st, 2025, is that correct?
Yes, and was indicted in the same
Okay.
as well.
Judge, I would like to be heard. Obviously, Judge, you were the judge and presided, and that
Right.
is what happened. But I do have concerns and do want to raise at this time. Obviously, what happened with a co-defendant
Right.
does not get to be mentioned in front of this jury, and I would ask that all the defense attorneys in this case, what specifically was found in her case is not admissible in this case, Judge, and should not have any bearing and should not be referenced as to that jury's actual findings and verdict.
Okay, well, the gist, all that's here is a request for judicial notice, so
Well, Judge, but the state has concern, why is he asking for judicial notice?
I don't
Are
know.
they trying to argue?
I don't know.
They're in a similar circumstance, in the same car.
But you weren't gonna try and get into that in guilt phase, are you, regarding what the verdict was of the Andrews co-defendant?
Well, my motion would be, my request would be for both, but I think specifically, I think it's especially relevant in the penalty phase.
Well, that wasn't the question. I asked you about guilt phase.
Well, my answer would be yes.
Okay, well, I don't think you're gonna be able to get into it guilt phase. Penalty phase may be a different story. We'll see,
Yes, yes.
okay? So,
And Judge, I'll file a motion limiting. I didn't know what his intent was, but obviously we don't believe that that should be mentioned or referred to in front of the jury for guilt phase.
I agree. Okay, I agree. It's not relevant for guilt phase. It may be for penalty, okay? So, even though there's not a specific motion pending, I will grant the request. I will take judicial notice if it is a relevant issue for me to take judicial notice of. But just so we understand each other, that's not admissible evidence in the guilt phase of the trial, okay? Penalty phase may be different. So technically, I'm granting the request as that's granted, as it's posed. Okay. Mr. Gonzalez, or you want to address the Ghost 187, or you want to do that after lunch?
No, Judge, we can do it.
Okay. And this would be defendant's first motion in limine.
Yes, Judge. This is a motion in limine seeking to prohibit any admission linking the Instagram account Ghost 187 to the defendant. A quick backdrop, Judge, as you know, you've heard some testimony earlier that Ghost 187 was provided initially by Detective Drabeck to Detective Ramos in the very couple of days inception of the investigation, and that's kind of what buttressed the Chevy Silver Cruise and part of the probable cause for the affidavit, search warrant affidavit for the cell phone and for the vehicle. On June 23rd, within that Instagram account, Ghost187__, the account included 3 items: an image of Tom Brady and Bill Belichick celebrating a Super Bowl victory, Number 2, a black screen containing 4 crying, laughing emojis, and a black screen displaying the phrase "Prosper and Junior G-Day Today 187 Babies." The defense believes that the state's going to attempt to elicit testimony with the opinion that Ghost 187 is an account owned by Rashad Murphy, or operated by Rashad Murphy. And also, unless they tell me otherwise, they're going to seek testimony from detectives interpreting, at least for one thing, the meaning or what Prosper and Junior G-Day Today 187 Babies means. Let me just ask real quick, are you guys still going to do that, considering we're not getting into incidents that happened before the 6th? Okay, I just want to know, that's fine,
Yes.
I got it, okay.
Yes, and I assume you're maybe seeking clarification for getting into prior incidents before.
Just clarification for my argument, whether I need to. So essentially, Judge, detectives are going to speculate, and they're going to provide testimony that Prosper refers to Prosper Johnson, a suspected 187 gang member who was killed in 2014, which obviously would be an incident that was originally within the table and the number of incidents that detectives testified in deposition. That was part of my prior motion, and certainly understanding that the court has limited the prior incidents to those that occurred in those 6
Right.
circumstances, this not being one of them. Because what the detective is going to testify to is, that in his opinion, that Prosper refers to Prosper Johnson, who was killed in 2014, that Junior refers to Gerard Adams, a relative of the defendant, who was killed in 2018, and he's further going to opine that G-Day means get back, and that the post reflects retaliation for the deaths of Johnson and Adams, namely as it relates to Charles Jones being killed in reprisal. And so certainly that's of concern to me for a number of reasons. Number one is that, again, they would have to foundationally determine that Mr. Murphy owned or operated that Ghost 187 underscore. And secondly, it dovetails into the type of opinion testimony that doesn't include specialized knowledge. It's simply saying, this is what I believe this says. Again, this is not coded language. This is not language that's being used over and over and over again in some underbelly of communication between gang members. And I would suggest to the court that in a sideline, in an underscored situation, that's improper. Going back to the 187 underscore, Ghost 187 underscore, the account records indicate the subscriber as an Arindam, Arindam, Omerta Nimrod, and then a registered email address, which is ghost187official@gmail. No identifying information, obviously, that would have anything to do with Mr. Murphy. They do attribute Detectives Griffin and Nieder that account to Mr. Murphy, and in asking about that and in getting testimony under oath, I asked Detective Nieder, and he declined to identify the informant that told him that this was an associated account, and when asked to identify anything else linking the defendant to that account, he said that's it on page 32. Detective Griffin, who is a 1200, an individual detective who looks after 1200 on a daily basis, I asked, could he show me a screenshot or a post or a story that you've captured that would show Rashad Murphy in it from that Instagram account? No. Can you and will you testify under oath that you have monitored that Instagram account and you saw Rashad Murphy on it? No. is it fair to say that your testimony is in that area as it relates to the Instagram account that would be somebody told you that it was his Instagram account? Yes, sir. Harken back also, Judge, to testimony last week from Detective Nieder, when I asked him essentially the same series of questions. Have you ever seen him on that account? Well, yeah. When? I don't know. With who? I don't know. Who else was on live during the posting on that account? I don't know. What were they saying? I don't know. Again, back to the overall issue and problem with the majority of the type of testimony I anticipate the jury hearing if the court allows it. Essentially, during the course of that deposition, the state asked some additional questions and said, hey, look, is there any other significance of 187? And Detective Griffin said, yeah, it's the penal code in California for murder, 187. And essentially, he conceded, though, that it's not known in the state of Florida that it has any significance, that it's not based on any kind of popular cultural type of reference, other than the fact that it's noted in a couple of gang-related movies, which is a problem in and of itself. And when I asked him whether or not it had anything to do with anything happening in Tampa, Florida, and certainly even more importantly, anything happening directly with Rashad Murphy, the answer was no. The other reason Detective Griffin gave for associating Mr. Murphy with Ghost 187 __, in addition to what I've just told you, which is, in my estimation, clearly speculative and certainly not admissible, Detective Griffin said, well, you know, he appears in some of these videos, not videos that are related to anyone being killed, okay, but he's in the background, and, you know, he's not really up front, and he's there and then he's not there, so I attribute that to him being the ghost. And that was his testimony under oath. Detective Nieder similarly testified, and I told you this about that he went live on this account at some point in time that he can't give us a date for, nor any other corroborating information for. And that is in his deposition on page 69. He also, Detective Nieder, admitted that he had limited familiarity with the defendant. He did not know whether or not there were photographs of the defendant that came on this account. He was not aware if any photographs were posted to this account. He wasn't aware of any connection between the defendant and the subscriber name or the email address. And essentially, I believe that the state cannot link Ghost 187 _ to Mr. Murphy, nor can they offer any permissible evidentiary foundation for suggesting that Prosper and Junior G Day Today 187 babies has any relevance to Mr. Murphy. And I believe those posts can't be authenticated and they're irrelevant. I would ask the court to prohibit any testimony purporting to link Mr. Murphy to Ghost 187 _. Any evidence derived from Ghost 187 _ Instagram account, and any opinion testimony purporting to interpret that phrase. I have set forth in my motion, Judge, case law, rules of evidence, particular circumstances that I believe support not only testimony linking Mr. Murphy to that account, but also posts that are associated with that account, and essentially would suggest that the state lacks any subscriber records connecting him to the account, any evidence tying him to the registered name or email, any posts or photographs or videos depicting the defendant on that Instagram account, any admissions as to ownership of that account, and any forensic evidence that establishes any control or authority or authorship of that account. I would cite the court to the Tharp case, which is at 777 Southern 2nd 385, a Supreme Court case in 2000, that the state seeks to interpret and establish motive, namely that this charged offense was committed in a reprisal situation, and it's not a conclusion based on the explanation of the language that we're talking about here. It's an inference as to his intent. And in Tharp, the Supreme Court reversed a first-degree murder conviction and a death sentence based in part on the improper admission of a witness's interpretation of defendant's statements. The defendant's cellmate was permitted to testify that when the defendant said he did a hooker, that means he killed him, and killed her. And the court held that this type of testimony was inadmissible because it's grounded solely in inference instead of any specialized knowledge or training. And I would suggest to the court that when you look at that, and even if you take into consideration any specialized training or knowledge, none of that would come into play when it provides the explanation that Detective Nieder did about his interpretation of that statement that was located on that account. And certainly I would suggest to the court that even if you did, certainly my objection as it relates to this motion, Ghost 87, that certainly an interpretation and an opinion statement by Detective Nieder should in and of itself be impermissible. Thank you.
All right, and I want to thank you, Mr. Gonzalez. In your memorandums, you put page numbers on your case law, so it did make it much easier for me to find what you were referring to. Okay, Ismer?
Yes, Your Honor.
So how are you going to prove that Rashad Murphy is somehow related to the account Ghost 187?